Afternoon. Welcome to this Liquid Collective panel on the legal analysis of staking and securities. I'm Evan Thomas. I'm the general counsel for Alluvial, which is a software development company supporting the Liquid Collective protocol. We have a fantastic panel of seasoned legal experts joining us today. Before I introduce them, I just want to, from a logistical perspective, if any audience members have questions, they're free to put them in the live stream chat. And if we have time permitting at the end, we can see if we can take some of those questions. With that, I'd like to introduce our panel. Again, we're very privileged to have them with us today. And so I just ask each of them to introduce themselves briefly. I guess we'll start with Jake. If you could introduce yourself, please.
Absolutely, and thank you, Evan, for having me and all of us for this. I'm Jake Chervinsky. I am Chief Legal Officer at Variant, which is an early-stage venture capital firm in the crypto industry.
Terrific. And then Mike, if you could introduce yourself.
Hey, I'm Mike Selig. I'm a partner at Wilkie Farr & Gallagher, working in the firm's crypto group. I help crypto projects and ecosystem participants navigate the complex and sometimes hostile federal regulatory landscape for crypto. Before joining Wilkie, I spent some time working at the Commodity Futures Trading Commission.
Terrific. And Scott?
Hi, Scott Bennett. I'm a corporate partner at Cravat. A lot of my work is in the capital market space, and a lot of it involves digital asset companies, helping them fundraise, helping them try to go public, working through regulatory issues and everything else across the ecosystem.
And thank you. And Tiffany?
Hi, I'm Tiffany Smith. I'm a partner at WilmerHale in the Securities department. I'm also co-chair of our blockchain and crypto working group, and the majority of my practice focuses on helping crypto, Web3, and technology companies understand the federal securities landscape.
Thank you, Tiffany, and thanks to all for taking the time to join us and speak to us today. As we get underway, I want to ensure that all of those in the audience have a common understanding of some of the technical and legal subject matter they'll be getting into. So to give folks that familiarity, perhaps Jake, if you could start us off and just briefly explain what we mean by staking.
Yeah, absolutely. Happy to do that. And I'll start with a little bit of blockchain 101, and I'll try to keep it pretty high level. But in short, staking has everything to do with providing security for a blockchain. And essentially, a blockchain is simply a database that people can use to add transactions or other types of information that is available to everyone around the world. And the magic about a blockchain is that it is not a database that depends on a single third party that has to be trusted and relied upon in order to maintain the database. Instead, it is a distributed database managed by many different people all around the world. And this begs the question, how do we make sure that all of these different people who are maintaining that database are following the rules and acting honestly? And what we need in order to do that is to have something called a consensus mechanism. This is something that incentivizes those people to, again, act honestly and validate transactions correctly and continue adding blocks to the blockchain according to the rules of the blockchain. And the first consensus mechanism that was created and really, the great invention of Bitcoin was the proof of work consensus mechanism, which uses sort of a carrot and stick approach in order to make sure that miners, who are the people who add blocks to the blockchain, are following the rules. On the one hand, it says the miners will have to put up something of value. They will have to risk some financial loss in order to participate in this network. And what they put up basically is computing power. The way that proof of work functions is that miners are spending a lot of energy to run computers that are solving very difficult math problems in order to add transactions to the blockchain. And the reward for them, if they do this correctly, is mining rewards. They essentially get paid in Bitcoin, the native asset of the Bitcoin blockchain, which is the incentive for them to follow the rules. But there's also a threat, which is that if they don't follow those rules, they will not be rewarded, and they will have spent and lost all of that money that they put into the computing power that they used. Now, the issue with proof of work, or at least one that many people have flagged, is that it is extraordinarily energy intensive. In some ways, it is very wasteful and environmentally impactful. And so a new consensus mechanism was devised called proof of stake, which uses essentially the same carrot and stick approach to incentivizing people to follow the rules and act honestly when maintaining a blockchain. But what it says is, instead of having an extrinsic resource like energy that you are putting toward the blockchain. Instead, you take that native asset, so for example, Ether in the context of the Ethereum blockchain, and then you stake it, you put it at risk, the value of that asset, in order to earn the right to act as a validator. Validators are the ones who maintain a blockchain in a proof of stake blockchain. And again, if they act honestly and follow the rules, they will be rewarded with staking rewards, which is more of that native asset of the blockchain. So that's the way in which they profit by following the rules. But if they don't follow the rules, they can be slashed, meaning they will lose whatever the value is that they've put up initially as their stake. And so again, staking is a reference to a security model that allows many hundreds or thousands of validators around the world to cooperate in order to maintain the security of a blockchain without simply saying all users of the blockchain must trust them in order to act honestly.
Thanks for that, Jake. So my understanding, I mean, there's a variety of ways of participating in staking, and so maybe we can go through what those are. Tiffany, we sometimes hear the term solo staking or home staking or native staking, which may very well all mean the same thing, and perhaps you could shed light on what that's referring to.
Sure, happy to. So going back to Jake's amazing explanation of staking, you have the process by which transactions are approved as the validation process. And so when you're talking about solo staking, the person that's putting up the stake and meeting whatever the requirements are of the network and for the stake, they perform that on their own. So thinking about ETH, the requirement to be a staker or a validator on the Ethereum network is 32 ETH. That person, or sometimes a company, would put that ETH up as their stake and perform all of the necessary functions to earn staking rewards. And as we talk about other examples of how staking works, like that's the thing to keep in mind with respect to solo staking. It's an actual person doing the functions, putting up the stake in order to earn the rewards on the network.
Right, and then we also hear references to staking as a service, and maybe Scott, you can explain that and contrast it with what Tiffany just described.
Certainly. So if you think about what you need to do to solo stake, what Tiffany was just talking about, if you're talking about ETH, you need 32 ETH. Well, that's like $100,000 worth of ETH in today's prices. That's fairly significant for an individual. You also need to go through some IT steps. You might need to have your own servers, or you contract with someone else, Amazon Web Service, something else, for processing power. You download software that you can run a validator. There's a whole series of things you need to do. And you need to have your ETH or your other proof of stake digital asset that you're actually holding and custodying so that you can solo stake. Many people can't do all that. So that's where other service providers come in, provide staking as a services. And there's probably two big buckets, at least the way that I think about it. One is if you are already on a custodial digital asset platform. So you're holding digital assets in Coinbase and Kraken, whatever. They already have custody. You're not holding your private keys. And so you can't really solo stake with those assets. And so those companies provide staking as a service on your behalf. There's not really another option to have staking. Now, we'll get to the SEC enforcement issues and some of the US limitations on staking the service because of the uncertainty as a legal matter that we're dealing with right now. But that's sort of one version of staking as a service, where you either opt in, or it's a system where everybody's opted in unless you opt out if they provide it, and they will stake on your behalf. Take the digital assets that you own, plus other people on the platform that have the same stakeable, proof of stakeable assets, put them together into the relevant amounts, 32 in the case of ETH for a validator, and then those crypto assets are staked as a service by the Coinbase, the Kraken, or whatever it may be. And then the rewards that come back are allocated back pro rata to the person who had their crypto assets on the platform and used that staking as a service, typically with a deduct for some portion of fees, 20, 25%, whatever it may be, that the company keeps as, in effect, the fee for providing that. That's sort of one model. Another model would be not necessarily custodial in the way that I just described, but a non-custodial staking as a service, where there is somebody out there who is, maybe you actually hold your crypto, you have a wallet, you have the private keys, et cetera, but you're using a service provider who is aggregating different people's digital assets to create the 32 in the case of ETH, to run the validator, to run the software, to go through the effort of actually providing those. And so you go there, but ultimately you still have your wallet, you have your private keys. And so that's kind of a couple of ways to think about it. And then I think one of the next topics, but I think somebody else is going to touch on it, is the liquid staking and some of the other interesting nuances in the market.
Yes, thanks for that, Scott. And picking up on that, Mike, I mean, maybe you could talk a bit about what liquid staking protocols, which are attracting increasing attention.
Yeah, absolutely. And liquid staking is almost kind of like the automated vending machine version of a staking as a service model. What you're doing in the context of liquid staking is depositing assets into a smart contract. So everything's happening on chain. The smart contract is actually managing the process of allocating the ETH to various validators. So Scott mentioned you need 32 ETH on the Ethereum blockchain to run a node. Rather than have a common custodian in the context of a SaaS model. So with the staking as a service, you would all have to be using the same custodian. All the users would have to be using the same custodian in order to reach that 32 ETH, and in order to then have a technical service provider run the validation services using that ETH and set the the withdrawal address back to that contract, or to that wallet. In this case, you have an on-chain smart contract where assets are being directed, and then the contract is allocating in 32 ETH increments to each validator. When the user deposits those assets into the smart contract, they receive a liquid staking token, which is essentially a receipt or a document of title that evidences the fact that the user has deposited assets into a contract for the purposes of staking those assets, and then is receiving this document of title evidencing legal and beneficial ownership of that ETH. And it can get interesting with things like restaking, where if you think about setting the withdrawal address to an eigenlayer pod, so that allows you to kind of stake the asset a second time, all this document of title or receipt is evidencing in the context of restaking now is that you've staked it twice, that the withdrawal address for that contract, or for that staking action, is now an eigenlayer contract. And you have this document of title that evidences all of that. So it almost is like a chain of custody, chain of title instrument that you can then transfer to a third party to demonstrate that you own this ETH, that they can go now to the smart contract and withdraw that ETH, and then it's subject to slashing, for example, the risk of loss, both at, maybe if it's restaking, at the contract level on the Ethereum blockchain, and then as well at the eigenlayer level. But it's really just an instrument. It's not the same as ETH. You can't pay your transaction fees on the network with the instrument. It's really just very much akin to what you would receive, if you drop off your dry cleaning at the dry cleaners and they give you a receipt saying you can come and pick this up, or you drop your grain off at a silo, they give you a warehouse receipt saying you can pick that up. These are really just title instruments, but they can be used in decentralized finance to service the underlying to a futures contract, or to function in a lending arrangement where you're using it as collateral. So it really just allows more flexibility, but you still are subject to the same mechanics of the staking network. So if you're staking on Ethereum, you still have to go through the withdrawal queue to actually pull your ETH out of the network. You still are subject to slashing and all of the unbonding requirements of the network itself.
Thanks, Mike. And so I guess moving then from what is staking itself, now sort of turning more to like the legal issues. I think just one question to start with for you, Jake. I mean, just the fact that these assets, leaving aside how they're staked and what issues that might raise, does proof at stake itself, does the nature of the ability to stake a proof of stake asset itself raise any legal considerations under securities laws? Does it transform that asset into a security in some fashion?
It shouldn't transform the asset into a security, although this has become, unfortunately, a somewhat controversial issue, I think more for political reasons than for legal reasons. But let me give you a bit of a sense of the legal argument, and then I'm sure others can weigh in more detail. But the main question when we're looking at any digital asset and wondering whether or not it will be treated as a security under the 1933 or 1934 Acts is the investment contract analysis and the Howey test. And surely everyone on this call and everyone who works in this industry is well familiar, fortunately too familiar, with the Howey test, which says that there is an investment contract in the presence of an investment of money in a common enterprise with a reasonable expectation of profit derived from the managerial or entrepreneurial efforts of a third party. And I think everyone agrees broadly that in the context of proof of work, there is no investment contract. Miners are not engaged in an investment contract, and the presence of proof of work as a consensus mechanism does not convert the native asset of the blockchain into an investment contract. And even the SEC, as hostile as they have been to our industry, has admitted that Bitcoin itself is not a security. And there's really nothing about the distinction between proof of work and proof of stake as consensus mechanisms that changes the analysis under the Howey test. And let me give you at least two reasons why both a proof of work and a proof of stake consensus mechanism should fail the Howey test. The first relates to the presence of a common enterprise. And without getting super deep into the weeds of the various different tests for a common enterprise in different circuits around the country, the test for common enterprise we typically look at is called horizontal commonality, which exists when there is pooling of assets among those who are involved in the enterprise and pro rata distribution of profits or sharing of losses as a result of participation. And that is simply not how a staking arrangement works. There is no pooling of funds in a typical staking system. Each staker, as we've been discussing, stakes their own assets and always has control over those assets, does not commingle them in any way with any other users or any other stakers in the system. So there is no pooling in the sense that applies in the presence of a common enterprise. In addition, there is no pro rata distribution of profits or sharing of losses. Each staker in the system will have their own unique result based on how they act in the protocol. First of all, not each staker will receive the same profits. They are, as we've been discussing, randomly selected or selected according to the consensus mechanism to validate the next block. So at any given moment on a defined timescale, some stakers may may validate many blocks, some may validate no blocks, and they will have a different amount of profit as a result. They also don't share pro rata in losses. The way that stakers lose their capital in some way in staking is if they don't follow the rules and then they are slashed. And not everyone gets slashed equally. In fact, the entire point of slashing is to incentivize each staker individually to follow the rules. So in my opinion, there is no common enterprise under the horizontal commonality test in a staking system. The other element of the Howey test that's worth talking about a little bit is the fourth prong, the requirement of a dependence on the managerial or entrepreneurial efforts of a specific third party or promoter. And we all think about this in the context of sufficient decentralization. In other words, the Howey test only applies when there is some party that has an information asymmetry and thus should be forced to make disclosures under the securities laws to make sure that the investing public has the same access to information as they do, given their privileged role in the ecosystem. And that simply is not present in the context of a proof of stake blockchain. All of the stakers, generally speaking, are unaffiliated and dispersed participants. They coordinate only in the sense that they are following the same consensus mechanism, but there's nothing that these stakers know that they have privileged access to some information or some privileged role in the ecosystem that it would make any sense to require them to make some disclosures. The beauty of a public blockchain is that all of this is public and transparent and can be seen by the public. And to the extent that there is some reliance on other people, it is reliance on a broad and dispersed group of individuals simply to perform the task of validating transactions, not in the sense that would trigger the Howey test. So in my opinion, there's really no distinction between proof of work and proof of stake in determining that this type of arrangement does not trigger the securities laws.
Thanks for that, Jake. And you touched on the Howey test. I just want to make sure that for the benefit of folks in the in the audience who may not be as deep in some of these legal issues. Maybe Tiffany, ask you if there's anything you sort of elaborate on Jake's explanation of the Howey test and then how it bears on the issues, and then also whether there's any other aspects of securities laws that are potentially relevant with staking. For example, the Investment Company Act. If you could just give an overview of some of the the legal considerations that bear on these issues.
Sure. So first off, I think Jake's explanation of the Howey test was correct. Like, investment of money in a common enterprise based solely on the efforts of others, and it's managerial, not ministerial. Another thing worth pointing out is that we look at this test to determine whether or not an asset or sometimes a scheme meets the definition of security. And there's many other definitions of security. There's note, there's stock, etc. Right? And so we're in this position because we're looking at the definition of security, and the investment contract test articulated by Howey is the most common test used in the crypto industry, as articulated by the SEC. And so, as Jake explained, when you're thinking about the investment contract test and whether or not a scheme is a security, you think both about the actual asset being offered as well as how it's being offered. And so, as Jake articulated, ETH, there's great arguments that ETH is not a security, and despite what we're hearing out of the SEC, some of the officials there, I agree with that. But let's look past that and think about putting that aside for a second, whether ETH or any other crypto asset for that matter could be offered as an investment contract with respect to staking. And then you start thinking about the way it's offered and whether or not the staking as a service type of offering meets the definition of Howey. Is there investment in it? Is there an investment of money? Is there a common enterprise? Are you reliant on the managerial efforts of others? And in at least one SEC enforcement action, which was settled, so it wasn't litigated. So the SEC was able to articulate the facts as it wanted to. So at least in one action, you had the SEC deem that an offering of a staking as a service product was an investment contract. There's also a number of actions at the state level in the form of C&Ds and other types of investigations going on. So that's still an open question. The issue that's worth flagging is that there's no standard way to offer a staking as a service program. So even though you might have an SEC enforcement action, it doesn't really give you clarity as to how you structure a program, right? It tells you in that particular way that program was structured. The SEC, thought that it met the different definition of investment contract, but it doesn't encapsulate every variation of a staking as a service type of offering. The last thing I want to point out about just securities law generally in the Howey test is another test that is relevant when you're thinking about staking and really crypto in general is this Gary Plastics case. And it's important to keep that in mind because it's another articulation of an instance where you can take something that's not a security, but offer it and package in a way that meets the definition of security. So in that particular case, they had bank CDs where everyone knows that bank CD, certificate of deposit, is actually in the definition of security. That is not it's in it by itself a security, but it was offered and packaged in a way that triggered the definition of security. You also asked about the 40 Act. And this comes up in the instances where you have staking as a service offerings where it's a custodial offering. Scott did a great job of articulating the custodial versus non-custodial offerings. And in those instances, you have what's called an investment. You have a test that's like the 40% test, where you look and see whether or not a company has assets on its balance sheet that are securities of more than 40%. And if you follow the thread that the SEC thinks that most crypto assets are securities, and you have a staking as a service provider, such assets, if deemed securities, could constitute more than 40% of the balance sheet of the issuer, the person who's offering the staking as a service program. We haven't seen that particular, although there's been attempts, we haven't seen successful articulation of that particular argument with the SEC. The closest one was in BlockFi, where it's a little bit of a different scenario where they deemed the loans that are being made as investable securities. But that's just something to kind of keep in mind when we're thinking about risks, especially if you're dealing with assets that the SEC has articulated that it believes are securities in any of the three lawsuits against the major crypto platforms. And then the last thing you wanted me to touch on was whether or not there's any considerations under the Commodity Exchange Act. I'll just touch on this briefly because this is Mike's area, so I always defer to Mike about CFTC things. But with respect to the liquid staking receipts that Mike described, there's questions as to whether or not those receipt tokens are swaps under the CEA. So that's another regime to keep in mind, as if you didn't have enough going on with the securities laws.
Thanks for that, Tiffany. And actually, why don't we pick up on that thread? We'll definitely want to come back to staking as a service and talk about some of the cases you referenced, Tiffany. But Mike, maybe you could just talk a bit about sort of liquid staking protocols and how the investment contract test, the Howey test, and other areas of securities commodity futures laws may bear on those protocols and how they might be considered under these legal regimes.
Yeah, so the important threshold consideration is always what is the asset that's being staked, right? Let's assume it's not a security. Let's assume it's a commodity. You're dealing with a different set of considerations from the world where if it's a security, the receipt instrument is likely to be a security as well. And so, there's not really a whole lot of analysis to be done there. In the case when you're dealing with a commodity, so if this current SEC, maybe they don't think ETH is a security, maybe they do. It's really hard to say these days. But let's assume it's a commodity. When you're taking a commodity and putting it in some sort of vehicle, so it could be a smart contract if it's a digital asset, it could be on a boat, it could be in a warehouse facility. You oftentimes receive these documents of title, bills of lading, warehouse receipts. They're really just these title instruments. And so in the digital world, you really have this construct that's useful for ensuring that you're able to move assets, put them into smart contracts, stake them, restake them, do all sorts of things with the asset, and still be able to come back and take those assets out to unwind those transactions. And that's really what these instruments serve as, these liquid staking tokens, liquid restaking tokens, et cetera. So when you're thinking about a Howey analysis on that, you're first considering whether there's an investment of money, right? Are you making any sort of investment in a common enterprise, in any sort of business? Do you have a business relationship with anyone? Well, really the nice thing about these liquid staking protocols is that they're designed to essentially operate on chain, to have relationships with validators that are really verifiable on chain, so that assets are being allocated on a round robin basis, essentially, to different validators. All of this happens based on programming. So really, you might have some sort of contract, right? But do you have an investment in a business and an enterprise? Likely not, because you're essentially maintaining that ownership, the legal and beneficial ownership of everything you're putting in the same way that if you go to a warehouse, or you put assets on a ship for transport, or you go to any sort of vendor or provider and give them something and they give you a receipt saying you can come pick it up, they're not taking ownership of that. You're not making an investment in their business. So the first prong of Howey, where you're making you're looking for an investment of money, arguably not met in these cases with liquid staking tokens. Then when you take it to the next element of a common enterprise, Jake went into detail on those elements of horizontal versus vertical, but really, collapsing that all down to a single construct, you're not putting anything into any business or any enterprise. You're using a service provider. And so really, when I drop off my dry cleaning, the same analogy applies here. I'm not investing the dry cleaning with the dry cleaner. I'm coming to pick it up later. When you're looking at the last two prongs, which often get collapsed down into one, an investment or expectation of profits based on the efforts of others, really you're expecting profits, if any. Arguably, you're not necessarily engaging in this activity to expect profits, but really to kind of participate in the network, to stabilize and secure the network, and participate in validation of transactions. But arguably, if you're looking for some sort of profits from that activity, it's based on the network itself, right? So that a liquid staking provider or staking as a service provider, or really any staking provider, they're not going out and engaging in real material activities. They're engaging in administrative activities, right? Like as Scott had mentioned earlier, there are certain things that are more like IT services, technical services, like setting up the node software, configuring the node, running MEV software, doing all of these things that are really just administrative in nature. They're like the IT department of, of your law firm, of your business, right? They're not kind of the profit center of the business itself. That's all stuff that someone could do on their own. We mentioned kind of staking as a service models with a common custodian. People can use a common custodian and stake on their own as solo stakers. They don't necessarily need to even have a provider. So what we like to think of these, we like to kind of consider these as more administrative services when we're at least engaging with regulators and trying to explain this sort of thing. And similarly, when you're talking about like these the efforts of others, which these all kind of get collapsed. The efforts are again of the entire network, of the validators, of this kind of enterprise itself around the technology, not really around any sort of provider. So that's kind of the Howey considerations. I know we touched briefly on some of the swap issues earlier on as well. It's kind of a similar analysis when you're thinking about the swap definition under the Commodity Exchange Act and the CFTC regulations. These aren't synthetic instruments. They're really title documents that you can be passed around and transferred for commercial reasons. Like you can think of a world where there's a cyber risk to one of your wallets and you want to move the assets without unstaking them. That's really a commercial decision. You might need to use them as collateral for a transaction and you don't want to unstake your assets. So there are many commercial reasons. And in the commodities world, in the physical world, we use these types of instruments all the time. It's uncommon for somebody to take grain out of a silo when they want to use it in a futures contract as an underlying to make delivery. You typically would pass delivery of a document of title. And so when you're thinking about the prongs of the swap definition, it's not an option. It's not an event contract. When you're thinking about this third prong of synthetic ownership of a financial instrument that is going to kind of provide price exposure to something, but not provide ownership. You really do have ownership of these, the underlying asset here. It's really just a title instrument. And additionally, there's kind of these exemptions that the CFTC has promulgated through regulation that pertain to commercial instruments. And this is really an exemption that's not often relied upon, but really fits here because these instruments are intended to serve commercial purposes, not really to be investment instruments. And so that's how I like to kind of analyze through these issues.
Thanks, Mike. we're going to move to staking services in a second, but I just wanted to press on one point that Jake referred to the pooling of assets and pro rata distributions as bearing onto the consideration of a common enterprise. And one of the things in the descriptions of both the staking protocols and I guess you do have, it seems, the pooling of assets for staking. So just curious, is there anything how would you address sort of analysis of that? I mean, if there is this actual pooling of assets in these protocols or these services, how does that not implicate the common enterprise element of the Howey test?
Yeah, I mean, so the 32 ETH construct is kind of an arbitrary number that the Ethereum team or developers kind of settled upon. But really the notion when you're moving assets into the contract and they're being allocated on a programmatic basis of 32 increments, the pooling itself that's occurring here, it's not pooling in the investment sense. The assets are being moved into a contract that's facilitating the staking of the assets. In commodities world, you deal with fungible bulk assets that are held in a grain warehouse or in a silo or in any sort of commodity warehouse. You kind of have to think similarly in terms of these smart contracts, because really what's happening, if you think about your commodities, let's say you own a bunch of grain, you can store it in your own facility, right? Like, so I have a small apartment in New York City. It's not going to store a ton of grain. And it's going to be expensive and burdensome, right? So I can use a service provider and get my own storage locker. All of the administrative headache and burden of that is now pushed onto the provider. Or I can have an even more efficient scenario where it's going to be cheaper for me and just easier to manage, where it gets stored in fungible bulk because it's a commodity with other people's stuff, right? I still own the percentage that I've put in. It's still my stuff. It's just a fungible bulk commodity. And so there's no reason for it to be in a separate facility for myself or in my own apartment or something like that. And so it's really an efficiency thing. And it goes back to these administrative services that we're talking about, right? Everything's done for administrative reasons, and, not to add edge or add a kind of more, speculative element to it. It's just more efficient, right? And going back to like a staking as a service model, if I were to use a common custodian, that again is just the custody element of the whole thing. It's not changing kind of the staking relationship and how the staking's performed. The contract is allocating in an efficient way, and people are able to move assets in an efficient way to kind of have them maintain in a fungible bulk. But at the end of the day, it's all going through the pipes of the Ethereum blockchain and through smart contracts. Nothing's being kind of pooled for an investment purpose. It's being pooled for efficiency and for administrative reasons.
Thanks for that, Mike. So just with our last 10 minutes or so, I'd like to talk about a case, decision in a case rather, just last week between the Securities and Exchange Commission and Coinbase, where Coinbase's staking services were at issue. And Scott, perhaps you could just take us through what the issues were in that case and sort of the gist of the judge's decision as it relates to Coinbase's staking services.
Yeah, certainly. To start, it might be helpful to just give a little bit of context of where that case is. So that was a motion for judgment on the pleadings. So a bunch of lawyer sort of mumbo jumbo, but effectively what that means is it's at an early stage in the case. There's been a complaint by the SEC saying, Coinbase, you violated a bunch of securities laws, one of which is staking. There's others in the case. And then Coinbase responds with their answer, no, we didn't, for all of these reasons. And then Coinbase moves for judgment on the basis of those pleadings to have a portion of the SEC's complaint, all or a portion, thrown out of court. That's effectively where we are. Pre-discovery, it's not an actual trial. And so the judge, when looking at that, makes a determination looking only at the pleadings and basically assuming the facts as alleged by the SEC are true. Not the person seeking the judgment. You assume the other person's facts are true. Then can the judge conclude as a matter of law that there has not plausibly been alleged a violation? And so that's the posture. So it's not a final determination. But in that posture, Coinbase sought to have the SEC alleged in their complaint that Coinbase's staking as a service platform violated the securities laws as an unregistered offering of Howey investment contract securities. Staking as a service on Coinbase available broadly to their users. If they were to actually register it, they would need an S1 with the SEC that would look sort of bizarre and wouldn't really provide all that much information that would be useful to folks for reasons discussed earlier. But that's effectively the allegation. You have an investment contract, and it's not the ETH that's being staked isn't the investment contract. It is the bundle of things around the staking as a service. So it is what is being so in Howey. The investment contract there related to orange groves, but it wasn't actually the orange groves. It was the orange groves combined with management services and so on and so forth. And so when you're talking about staking as a service, whether or not you have a Howey investment contract, again, it's sort of this broader context to add it all together. Do you have an investment contract? In that, the SEC has to allege all of the elements of Howey, because if a person claiming not to have an investment contract security can defeat one element of Howey, you win. And so in connection with that, Coinbase was arguing, multiple things, but there was particularly a focus on no risk of loss, because the underlying crypto is continued to be held and owned by the users and the owners of the ETH or the other proof of stake digital assets that were on there. Was 5 different ones that they provided the service for. And Coinbase agreed to indemnify, make whole anybody if there was slashing penalty, et cetera. There'd never been a slashing penalty on Coinbase. So you combine all those things together, argument there's no risk of loss. The risk of loss, sort of no investment of money and no risk of loss is a challenging one just based on the case law and the way this often gets argued. Because if there's kind of any potential risk of loss, the SEC will often say that, yes, clearly there's investment of money and there's some case law to support that, although there's case law goes in different ways. So winning on the no investment of money is difficult, not impossible, but difficult. And then a lot of the meat of argument was going to efforts of others. Is Coinbase and providing the staking as a service platform and what they're doing essential managerial and entrepreneurial efforts, or is it really administrative, clerical, ministerial? And so this goes back to the question of, are we talking here about an investment manager? Think about the management team, the board of directors that are running a business and making important decisions about how to move a business forward versus ministerial services. And I think a lot of the folks that are on this call, and myself included, we were involved in an amicus brief in the Coinbase matter that we filed on behalf of the DeFi Education Fund, where we very much argued that this is ministerial IT services in terms of what really Coinbase is doing. Validators are publicly available open source software. They can be run on Amazon Web Services. They can be run, kind of easily in the same across solo stakers, Coinbase staking, etc. Where the judge really ultimately did not grant Coinbase the decision, there was a few things. One, the judge focused on some of the statements that Coinbase had made around the fact that staking on your own is complicated, confusing, and costly, was the quote. Also, that there have been various statements about how much money people have made through staking, profits people have received through staking. So the judge was definitely focused in quite a bit on the amount of public statements that make it look like there's a profit-making opportunity here. And then the other thing that the judge was focused on is something more than ministerial efforts, that there's a lot of hard work that needs to be put into maintaining server runtime at 100% to get the most rewards. And some of that, to be honest, I was struggling to conclude that was all that compelling, because the reality is slashing penalties are quite rare, require something that's really an attack on the network, and just maintaining a server uptime. A lot of people use external cloud-based services anyway, and they're not doing anything with respect to that. And that's how a lot of staking as a service works anyway. And there is really no concept of, in the proof of stake world, we are going to just blast the most computing power at this problem to somehow create greater rewards. That's just not how proof of stake works. And that's why we pivoted in a lot of cases from proof of work into proof of stake, because you don't want people doing that because of the energy drain issues. And so there are statements in the decision from the judge talking quite a bit about the efforts involved in maintaining server uptime, in doing all these things to make sure that you're optimizing and maximizing the return for staking. And I think there's real holes in that logic. But going back to the original point I made about the case, that the procedural posture is to, as a factual matter, take what the SEC said in its complaint on its face and say, should we dismiss it if we assume what's in there factually is true? So hopefully, as things move forward, there'll be a better opportunity through discovery, further arguments, et cetera, to refute those facts.
Thanks so much, Scott. We're coming up to near the end of our scheduled time, but I do want to ensure that everyone gets a chance to weigh in on this case. Maybe Tiffany, really just any thoughts on the case itself, its implications for staking more broadly, or any sort of thoughts on the judge's reasoning that you'd offer, and then we'll go to Mike and Jake for their perspectives as well.
Yeah, I think the point that Scott began and end with the fact of where this case is probably the most important one, right? Because even if we were in a world in which the staking claim was dismissed, the SEC ultimately probably would still appeal it, right? That's likely going to happen with Ripple. So I think in this world, unfortunately, we're just in flux. And even though this may be in some respects a minor setback because it wasn't dismissed, I'm hopeful that, when the parties get into discovery, some better facts come out. And in particular, it's important to note that these were the SEC's allegations of the past. And we've seen other instances where it's not clear that the SEC's articulation or understanding of what was going on is always accurate. So I think, we shouldn't get too worked up about this case and just look forward for the discovery, the next phase of the trial.
Terrific. Mike, over to you for any comments.
Yeah, I mean, I agree with everything that's been said. I think there's definitely a dynamic here where a large amount of stake is performed by staking as a service providers at, the majority probably of retail staking, aside from, there are a number of solo stakers, but a lot of the staking on many of these networks is being done by these types of staking as a service providers. So I do think there's, a number of us that have expressed frustration at the hostility that the SEC's kind of had towards the asset class. This, to me, is another kind of politically charged way to kind of undermine the use of these networks, undermine the ability of these networks to really decentralize, which ultimately is kind of, somewhat, if you look back to like the Hinman speech and some of the prior administration's views, a lot of the goal was to make these networks more decentralized, more like Bitcoin. And this, to me, is kind of a way to kind of attack that and undermine the decentralization of these networks. And so, I just think there's a political motive here. And, the reasoning behind saying certain administrative and ministerial technical services are, for some reason, kind of more of an investment contract than just the idea of holding your assets with the custodian is really mind-boggling to me, because they're running, very similar technology. It's very important that they custody assets in a certain way to maintain the security of those assets. And then to make the argument that just because you're earning rewards, if it's configured in a certain way, that's better for the network, better for the decentralization, undermines the idea that it could be a security. It's just really an odd way to approach regulation of the asset class.
Thanks, Jake. The last word to you.
Excellent. Well, I don't have much to add. I think that Scott, Tiffany, and Mike really nailed this one. So the only thing I'll do is to zoom out a bit and remind everyone that ultimately we have to interpret laws and regulations based on the underlying policy concerns that they are intended to address. And when you look at staking, whether it's native staking on chain or it's a staking as a service provider, we just don't see the type of principal agent relationship or the type of information asymmetry that would justify applying the securities laws. And I think the same is true for a lot of other federal regulatory frameworks, like those that the CFTC enforces that we've been discussing today. They just don't seem to apply in this type of context. That's not to say that this is an unregulated space. There are many other laws and regulations that do ensure consumer protection and investor protection in this type of environment. But the securities and commodities laws just aren't the right fit for this type of technology. So I'll leave it there.
So thanks for ending on that note. And with that, thank you first to our audience for joining us, and for your and for being willing to learn from our esteemed experts on this panel. And again, close by thanking our panelists for taking the time to share their knowledge and their expertise with all of us today. So thanks very much for your time, and have a great rest of your day.